Welcome to
Ducky Channel.
Thank you for joining me. We're going to start with part 2 of the brief of Defendant Appellant Steven A. Avery. And we're going to start with part 2, defense. Part 2, the defense case. Mr. Avery was represented by retained attorneys Dean Strain, Mr. Strain, and Jerome Buting, Mr. Buting. Mr. Avery paid trial defense counsel $220,000 for his defense. In contrast with the state's 14 expert witnesses, trial defense counsel presented 7 witnesses in total, only 2 of whom were qualified as experts. Part A. Defense forensic evidence. Mr. Avery's blood in the RAV4. Trial defense counsel did not have a blood spatter expert. Trial defense counsel only offered one source for the allegedly planted blood of Mr. Avery, the 1996 blood vial, which was located in an unsecured area of the courthouse. Footnote 4. In the Dassey opinion, the court references the state's theory that Brendan participating in raping and murdering Mrs. Halbach with Mr. Avery, which contradicts the state's theory in Mr. Avery's trial that he was the only perpetrator. In Brendan's trial, prosecutor Kratz claimed that Mrs. Halbach was killed by Mr. Avery stabbing her in the stomach, Brendan slitting her throat, and Mr. Avery manually strangling her. Prosecutor Kratz claimed Mrs. Halbach was killed in Mr. Avery's trailer, not shot in Mr. Avery's garage. Obviously, this theory excluded anyone but law enforcement from planting Mr. Avery's blood. Trial defense counsel did not do their own independent testing of the 1996 blood tube. Rather, they relied upon the testimony of Janie Arvizu, Mrs. Arvizu, to try to refute Dr. LeBeau. Mrs. Arvizu held a bachelor's degree in biochemistry and worked as a laboratory quality auditor. Mrs. Arvizu testified that Dr. LeBeau's experiment did not account for the absence of a limit of detection. His protocol was rushed, and no one had attempted such an EDTA experiment in 10 years. Additionally, trial defense counsel presented Raleigh Johnson, the owner of Mr. Avery's trailer, who testified he had observed that the cut on Mr. Avery's finger was present prior to October 31, 2005. Discovery of RAV4 key with Mr. Avery's DNA. Trial defense counsel failed to subpoena the bookcase to demonstrate for the jury the credibility of Sergeant Colburn's description of dislodging the key from the back of the bookcase and having it migrate to the northwest side of the bookcase by Mr. Avery's slippers. Mr. Avery's trial defense counsel did not have a DNA or trace expert examine the key. Mr. Avery's DNA on hood latch. Trial defense counsel did not have a DNA expert analyze a swab from the hood latch to determine if the quantity of DNA was consistent with an individual opening a hood latch one time. Trial defense counsel did not have a trace expert analyze a hood latch swab to determine if it had actually swabbed a hood latch. Bones in Mr. Avery's burn pit. Trial defense counsel claimed the bones of Mrs. Halbach were planted in Mr. Avery's burn pit, but presented no evidence as to who planted the bones, when, or how they planted. Dr. Fairgrave would not offer an opinion as to whether Mr. Avery's burn pit was a primary location of the body burning, and admitted that he had only looked at photographs and not examined the actual bones. Mrs. Halbach's DNA on bullet. Trial defense counsel did not have a ballistics trace or DNA expert conduct experiments or microscopically examine number FL. Trial defense counsel speculated that because Ms. Culhane had contaminated the control sample for number FL, she may also have transferred Mrs. Halbach's DNA onto number FL. Trial defense counsel stated that Ms. Culhane had Ms. Halbach's DNA from the RAV4 cargo area, quote, sitting right there on her bench. So, quote, you can't tell how and whether Teresa Halbach's DNA ended up there in the same extraction mechanism. Part B. Third-party suspects. On January 30, 2007, the trial court precluded Mr. Avery from offering direct evidence, quote, that a third party other than Brendan Dassey participated in the commission of the crimes charged in the amended information. Trial defense counsel named third-party suspects pursuant to State v. Denny, which included Mr. Taddick, Andre Martinez, James Kennedy, Charles Avery, Mr. Fabian, Earl, Blaine, Bobby, and Brian Dassey. The trial court found that in the absence of motive, it certainly may be more difficult for the defendant to offer evidence which is relevant and material connecting a third person to the crime. The court simply finds nothing in the offer made by the defendant that goes beyond the level of speculation. The trial court did allow trial defense counsel in its closing to mention other suspects that were being investigated by Special Agent Thomas Fassbender, S.A. Fassbender, and Investigator Weger. Trial defense counsel criticized that investigation of these suspects by pointing out their suspicious behavior. Trial defense counsel named George Zipper, Mr. Zipper, Mrs. Halbach's ex-boyfriend Ryan Hilligus, Mr. Hilligus, Mrs. Halbach's roommate Scott Blodorn, Mr. Blodorn, Mrs. Halbach's former married lover Bradley Scheck, Mr. Scheck, and Mrs. Halbach's business associate Thomas Pierce, Tom Pierce, Mr. Pierce. Specifically, trial defense counsel pointed out Mr. Zipper's strange behavior, the lack of alibi for Mr. Hilligus, Mr. Blodorn, and Mr. Scheck, and the failure for 4 days of Mr. Blodorn and Mr. Pierce to report Ms. Halbach missing. On March 18, 2007, Mr. Avery was convicted following a jury trial of first-degree intentional homicide, contrary to Wisconsin Statute 940.01, and felon in possession of a firearm, contrary to Wisconsin Statute 941.29. The jury found Mr. Avery not guilty on mutilation of a corpse. Section 3. Post-conviction and direct appeal. On August 3, 2007, Suzanne Hogopane and Martha Askins, prior conviction counsel of the Wisconsin State Appellate Defender's Office, were appointed as direct appeal and post-conviction counsel. On June 29, 2009, they filed a motion for post-conviction relief on Mr. Avery's behalf, pursuant to 809.30, seeking a new trial on grounds that, number 1, the trial court improperly excused a deliberating jury, and number 2, the trial court improperly excluded evidence of third-party liability. Mr. Avery's motion included a claim of ineffective assistance of counsel on the jury issue. On September 28, 2009, an evidentiary hearing was held. On October 29, 2009, a brief in support of Mr. Avery's post-conviction motion was filed. On January 25, 2010, the motion for post-conviction relief was denied by the Honorable Patrick L. Willis in a written order. There was an appeal from that decision, and that decision was affirmed by the Appellate Court on August 24, 2011. Footnote number 5. This court, in its 2011 opinion, erroneously stated that, quote, Steven Avery was convicted as a party to a crime of the first-degree intentional homicide of Teresa Halbach, emphasis added. The party to the crime language was in the Second Amendment information, which the state had to dismiss when Brendan recanted his confession. The information upon which Mr. Avery was convicted refers to the original information and did not have the language, quote, party to the crime. On December 14, 2011, the Wisconsin Supreme Court denied the petition for review, pursuant to 808.10. Part 4. Pro Se Post-Conviction 974.06. On February 14, 2013, Mr. Avery filed his first and only pro se collateral post-conviction motion, pursuant to Wisconsin Statute 974.06. The motion was denied by the Honorable Judge Angela Suckowitz on November 23, 2015. Mr. Avery claimed that trial counsel failed to A. raise a Sixth Amendment violation regarding Mr. Avery's jail conversations with his trial attorneys, B. suppress evidence obtained by invalid search warrants, C. sever the felon in possession of a firearm charge, D. develop an argument based upon available information that the state had planted evidence, E. strike biased juror Carl Wardman, F. investigate relevant material issues. Mr. Avery claimed that his appellate counsel failed to argue, quote, retroactive misjoinder. Additionally, Mr. Avery claimed the trial judge was biased, and both trial and appellate counsel failed to raise the issue of the state commenting on Mr. Avery's silence in the state's closing argument. On November 23, 2015, the court denied all of the claims in Mr. Avery's motion as lacking any merit. Mr. Avery filed a notice of appeal on December 3, 2015. Part 5. motion for scientific testing 971.23, 974.07, and second post-conviction 974.06. Mr. Avery obtained current post-conviction counsel in January of 2016. On August 26, 2016, current post-conviction counsel filed a motion for post-conviction scientific testing pursuant to Wisconsin Statute 971.23 and 974.07. On September 12, 2016, the Appellate Court granted current post-conviction counsel's motion to stay Mr. Avery's appeal and remand the case to the Circuit Court, which entered an order on November 23, 2016, for specific items to be tested. Pursuant to that order, scientific testing was performed, and current post-conviction counsel filed a motion for post-conviction relief on June 7, 2017, and also filed a motion to dismiss Mr. Avery's pro se appeal, which was pending with the Appellate Court. That motion was granted on July 24, 2017. On September 18, 2017, Mr. Avery's current post-conviction counsel reached an agreement with the state to allow the June 2017 motion to be amended without opposition to add and remove claims and for additional scientific testing of evidence. Scheduling for a potential evidentiary hearing in the spring of 2018 was discussed because both sides believed the Circuit Court would grant an evidentiary hearing on Mr. Avery's claims. On October 3, 2017, prior to the state working out the logistics of the RAV4 testing, the Circuit Court issued an order summarily denying Mr. Avery's June 7, 2017 motion for post-conviction relief without ordering the state to respond to Mr. Avery's motion or granting an evidentiary hearing. On October 6, 2017, current post-conviction counsel filed a motion to vacate the October 3rd order, informing the court of the September 18th agreement between Mr. Avery's counsel and the state for additional scientific testing and an amendment to the current post-conviction counsel motion for post-conviction relief. When the Circuit Court did not timely respond to the current post-conviction counsel October 6 motion to vacate, current post-conviction counsel filed a motion for reconsideration on October 23, 2017, and several supplements thereto on October 31st and November 1st, 2nd, 16th, and 17th, 2017. The motion to reconsider and its supplements contain new evidence that developed after the June 7, 2017 filing and after the filing of the original motion to reconsider on October 23, 2017. On November 17, 2017, current post-conviction counsel filed a timely notice of appeal from the October 3, 2017 order. The Circuit Court did not rule on the October 6, 2017 motion to vacate until November 28, 2017, when it denied current post-conviction counsel's motion to vacate the October 3, 2017 order in its motion to reconsider and its supplements. Current post-conviction counsel filed an additional timely notice of appeal on November 3, 2017, from the Circuit Court's order of November 28, 2017. On May 18, 2018, current post-conviction counsel submitted a motion to supplement the record on appeal with a CD, disclosed for the first time by the state on April 17, 2018, which current post-conviction counsel contains impeaching and or exculpatory evidence. The Appellate Court remanded to the Circuit Court to, quote, conduct any necessary proceedings and enter an order containing its findings and conclusions within 60 days after the supplemental post-conviction motion is filed. On September 6, 2018, after this court's deadline for decision had elapsed, the Circuit Court, without conducting any proceedings, denied, quote, all motions submitted by the defendant on or after July 6, 2018. On January 24, 2019, current post-conviction counsel submitted a motion to the Appellate Court to supplement the record on appeal with an undisclosed police report dated September 20, 2011, which, according to Mr. Avery's current post-conviction counsel, reflects law enforcement's transfer of multiple human bones from the Manitowoc County gravel pit to the Whiting Funeral Home for return to Teresa Habach's family. Mr. Avery alleges that the state violated its statutory duty to preserve evidence, see Wisconsin Statute 968.205, and the actions violated Mr. Avery's constitutional due process rights. On February 25, 2019, the Appellate Court granted the motion and allowed current post-conviction counsel to file a supplement post-conviction motion. The Appellate Court further ordered the Circuit Court to conduct any proceedings necessary to address the claims raised in the supplemental post-conviction motion and to enter an order containing its findings and conclusions. On August 9, 2019, the Circuit Court, without conducting any proceedings, denied the motion, finding, quote, that the defendant has failed to meet his burden to establish that Wisconsin Statute 968.205 was violated, or his constitutional rights were violated under the provisions of Youngblood v. Arizona. Mr. Avery now appeals.
'Cause the days are gonna whisper, and the months are gonna talk, until the years yell out the truth. Time will tell, time will tell on you. When a train whistles far away, and when the cold